What happens when a divorced couple agrees to a parenting plan? One parent moves closer to a major city, and suddenly the question becomes, where should the children go to school? That's exactly the battle unfolding in today's courtroom. On one side, a mother fighting to keep her children rooted in the community they've always known, their schools, friends, doctors, sports teams, and extended family. On the other side, a father who says the existing parenting arrangement and his role as primary residential parent give him the authority to make educational decisions. But here's where things get complicated. This isn't just about school districts. It's about legal technicalities, parenting agreements, relocation laws, and a single clause buried inside a parenting plan that could completely change the outcome of this case. As testimony unfolds, objections start flying. Attorneys begin challenging each other's arguments, and the judge uncovers a critical issue that neither side can avoid. Did the parties bring the wrong case to court? And could one overlooked provision decide everything before the court even reaches the children's best interests? Stay tuned, because this hearing takes a surprising turn that neither side appears fully prepared for.
This is, I believe it is Mrs. Washington's petition that's been filed in opposition to a relocation.
Yes, Your Honor.
All right. Then it's your petition, we'll let you put on your proof. So.
I'll call Ms. Washington.
Noel Washington.
Okay. And you were previously married to Jeffrey Washington, correct?
Yes.
And you guys entered a parenting plan, which we had done that was reportedly temporary. I believe the court's made a ruling on that. But at that time that was entered, there was an idea that Mr. Washington might relocate at some point due to his employment.
Yes.
Okay. And so I believe the judge has already ruled that the relocation statute doesn't apply, but we were supposed to be heard today about school enrollment, which you have objected to for a number of reasons. Can you state the reasons that you've objected to the move?
Yes. The kids are established here. They've been going to school here. Their family's here. Their pediatrician's here that they've been seeing since they were little. Their dentist is here. My daughter, Nyla, she's in cheer at the middle school in White Bluff. And then my 9-year-old daughter, Callie, I had it to where she could do summer school because she didn't do well on her TCAP, even though she made good grades. So instead of them doing summer school, they were going to let her, throughout the upcoming school year at White Bluff Elementary, do tutoring so that she wouldn't be held back.
Okay. And are there any other reasons that you don't want the children to have to go to school in Davidson County?
Right away, we're seeing the mother's central argument. Notice how she's focusing on stability rather than attacking the father directly. Her case is built around continuity, same schools, same doctors, same extracurricular activities, and the same support system the children have known for years. In family court, judges often pay close attention to whether a proposed change disrupts a child's established routine. But here's the challenge. Simply proving that children are comfortable where they are doesn't automatically mean a move should be blocked. The real question is whether the law actually gives the court authority to stop it. What do you think? Should preserving a child's routine outweigh a parent's ability to relocate for work?
Just that I don't feel like it'd be beneficial for them, the kids,
Why?
because they don't want to go.
Objection, Your Honor. The children's preferences are not a factor in this matter, and that's hearsay.
And there it is, the first major objection. This is a classic family court issue. Many viewers are probably thinking, why can't the court just listen to what the kids want? But legally, it's not that simple. The attorney immediately objects because testimony about what the children allegedly said can be considered hearsay, and younger children's preferences often carry limited legal weight depending on the circumstances. What may seem like common sense to the average person can become a procedural problem in court. This is a reminder that family law isn't just about emotions, it's also about rules of evidence, and those rules can dramatically shape what the judge is allowed to consider.
Remember, we can't talk about what the children have said.
Yes, I
Okay.
apologize.
That's all right. And so You said that your which daughter, Callie, is in tutoring or needs tutoring. Is that
Yes,
correct?
throughout the upcoming school year.
Okay. Is she supposed to be doing that this summer at all?
There was an option for her to do summer school, but it would be hard with the week that she's with her father for him to get her to summer school during that week.
Okay. Well, do you know if they offer tutoring at the school that she might be going to?
I do not.
Do you know what school she might be going to?
I do not.
Okay. And your children are in different grades, correct?
Yes.
Your youngest one is not even in school yet, is that correct?
Yes.
And your oldest one is still in middle school?
She's in middle school. She's going into the 7th grade.
Okay. And they have friends here?
They do.
They have family here?
They do.
And do they have any family in Nashville besides Mr. Washington?
I believe his sister.
Okay. And so, given the situation of y'all's plan, where you have the children somewhere, you have to take them to school, and that might, is that going to be difficult for you?
It would be difficult to travel to get them there on time
Okay.
from West Dixon to Hermitage.
Okay. How long does that take to drive?
I'm not sure, depending on the exact location of the school that he would be trying to enroll them in.
Okay. Was there anything else going on that makes White Bluff better, as far as, in your opinion, of where they should go to school?
No, ma'am. Just,
What we've talked about?
yes, ma'am.
Okay. And you said your children make good grades,
They do.
and they participate in many activities. Is that
Ye-
correct?
Yes, ma'am.
And so Nyla participates in cheer.
Yes,
Is there
ma'am.
football or anything for the other ones?
They were in football and cheer, but that hasn't started up yet for this year.
Okay. And do you know if they'll still be able to participate in those type of activities when they get there?
They will here. I'm sure they could there too, if that's what the kids wanted to do.
All right. I'll pass the witness.
All right, Ms. Tucker, you have questions for this witness?
Just a few, Your Honor. Can you hear me okay?
Yes, I apologize.
No, it's okay. Just making sure. Ms. Washington, you mentioned difficulty getting the children to school during your time. But isn't it true that during the school year, your ex-husband, Mr. Washington, he has the children primarily during the school year, correct?
On paper, yes.
Okay. And so in your parenting plan, he has them for every 2 weeks. Isn't it true that he is the one taking them to and from school almost, would you say, 3 or 4 days a week?
It depends. A lot of it was my grandfather that he was living with.
Okay, but I guess I'm asking about the plan. Isn't it true that he is to take school 3 or 4 days each week, correct?
Something like that.
And you take them significantly less to school during the school year, 1 day a week max, correct?
No, it is more than 1 day a week.
Okay. Isn't it true that it's you pick them up from school on Thursday, then you're responsible for Friday every other week?
Yes, and then the off week, I have them on a Wednesday, I believe.
On a Wednesday. Okay.
I don't have the plan in front of me.
Okay. Well, so significantly, like you said, on the off week, you have Wednesday, and then on the week where you have more time, it's Thursday through Friday, correct?
Yes,
And you are employed, correct?
yes.
Are you employed as a waitress,
Server,
server? And your ex-husband, he is employed, as I believe you know, as a full-time property manager, correct?
yes,
Okay. And so he is responsible for taking them. Well, and let me withdraw, I'm sorry. According to your parenting plan, he has about 80 more days per year of parenting time responsibilities than you, correct?
on paper, yes.
Okay. And that is a court order paper, correct?
Yes.
So that's what should be followed. And would you agree that since he is primarily the one taking them to and from school, it is in your children's best interest to not have to commute multiple hours a day the majority of the time to go to school in White Bluff?
I'm sorry, I'm not understanding what you're asking me.
Okay. So if your ex-husband, Mr. Washington, is taking the kids to and from school, and he works in Nashville, in Hermitage, do you agree it would be in your children's best interests to have a shorter commute to and from school when they're with their father?
I'd agree that'd be for both of us.
Well, but you agree.
This cross-examination is becoming incredibly important because the father's attorney is shifting the focus away from emotions and toward logistics. Instead of debating friendships or extracurricular activities, he's emphasizing parenting time, transportation responsibilities, and daily school routines. That's a strategic move. If the father is responsible for getting the children to and from school most of the time, then proximity to school suddenly becomes a significant factor. Notice how both sides are talking about what's best for the children, but using completely different definitions of the phrase. One side defines stability as staying put. The other defines stability as reducing commute time and simplifying the daily schedule.
That Mr. Washington has your children during the school year in particular a significant majority of the time, correct?
That's a part of the parenting plan, but that's not what happens.
Are you saying you don't follow your court-ordered parenting plan?
I say that we discuss things and he's not there a lot of times. My grandfather's the one that usually takes the kids, picks them up, has them till he gets home around 7-something at night.
Whoa, this exchange may be one of the most revealing moments in the entire hearing. The attorney asks a straightforward question about the parenting plan, and suddenly the conversation shifts to whether the actual day-to-day arrangement matches the court order. That's a huge distinction. Courts care deeply about written orders, but they also recognize that real life sometimes operates differently. The mother's testimony suggests that the practical routine may not match what's written on paper. That creates an interesting tension. Should the judge rely on the signed agreement, or should the court focus on what has actually been happening in the children's lives? Let us know where you stand on that issue.
And that's because Mr. Washington is working in Hermitage, correct?
Yes.
Okay. Isn't it true that your ex-husband, Mr. Washington, is very much involved in your children's education, helping them do their homework?
For the most part, yes.
And he's very supportive of their extracurricular activities, correct?
For the most part, yes.
Isn't it true he even coached your son's football team at one point when he was in football?
He did.
And per your parenting plan, your ex-husband is responsible for those extracurriculars, the ones you mentioned, cheer, football, any other softball. He's responsible for paying 75% of all of the costs of those things, correct?
Yes.
Right. And so, okay. I think I have no further questions for this witness, Your Honor.
Correct, Ms. Coffenberry. Thank you, ma'am. You may step down and have a seat at the table by your lawyer. Ms. Coffenberry, you may call your next witness. Step right around here, please, ma'am. Raise your right hand. Let's place you under oath.
Yes.
State your name for the court, please.
Anita Nicholson.
And how are you connected to Ms. Washington?
I'm Noel's aunt.
Okay. And have you had an opportunity to observe these folks' involvement in the children's lives?
I have. I've been there ever since they've been born.
Okay. And so, have you, since they have been separated and gone along, have you seen Noelle with her children?
I have.
And have you known her to have them with her and take them places?
Yes.
Okay. And have you observed her involvement with them in taking care of their school, education, and things like that?
Yes, and picking them up when she has them and taking them on time.
Okay. And that seems to work well.
It does. The kids are happy there.
So, do you have
Your Honor,
concern?
objection to the kids happy. I'm not sure how she can testify about the children's.
She can testify about what her observations are of the children's behavior, and she cannot repeat what they say, but
Another objection, and once again we're seeing the battle over what evidence is relevant. The aunt wants to testify about changes she's observed in the children, while opposing counsel argues that this is simply an indirect way of introducing the children's preferences. This is a common courtroom strategy, sometimes described as trying to get evidence in through the back door. The judge's response here is critical because it draws a line between observable behavior and statements made by the children themselves. Family court hearings often hinge on these distinctions, and a single evidentiary ruling can dramatically affect the direction of testimony.
she can testify about their general demeanor and behavior, so overrule the objection.
Okay.
I've been in their life a long time,
Okay.
and I'm very active in it.
Okay. So have, since this move idea came up, have you observed any changes in the children?
Your Honor, objection. The children are under the age of 12. Their preferences in this matter are not relevant. And I think they're trying to backdoor what their preference is by her observations, but that's not statutorily a basis for a custody decision.
Well, this court has previously found that the address that Mr. Washington is relocated to is less than 50 miles.
Yes.
Therefore, the parental relocation statute is not triggered. So what we now have is basically Mrs. Washington's objection to the school being changed for the children. And frankly, that would require a petition to modify the parenting plan that was adopted by this court. And that parenting plan, which was an agreed parenting plan, not one ordered by the court, but an agreed parenting plan, was filed February the 13th of 2026, signed off on by both Mr. and Mrs. Washington. In that parenting plan, Mr. Washington is designated as the primary residential parent. And it apportions the days at 140 days per year with the mother and 225 days with the father. He goes on to set out that the mother will have the exercise her parenting plan every other week on Thursday afternoon, when she'll make arrangements to pick up the children from school until Monday morning, when the mother will return the children to school. The schedule is supposed to begin February the 11th, 2026. Then it goes on to talk about the off week. She gets Wednesday afternoon until Thursday morning when she takes the children back to school. So she sees them every week. More concerning to this court is the subsection J.
This is the moment that changes everything. For nearly the entire hearing, the discussion has centered on schools, parenting responsibilities, and relocation. But now, the judge has discovered something buried inside the parenting plan itself. Subsection J. Suddenly, the court isn't debating whether the move is good or bad. Instead, it's asking a much more fundamental question. Does this case even belong before the court in its current form? Viewers, pay close attention here. Sometimes, courtroom outcomes aren't decided by dramatic testimony. They're decided by the exact wording of documents signed months earlier. And that appears to be what's happening right now.
Other following special provisions apply. The very first one of those is that this parenting plan shall remain in place until July the 12th of 2026. The parties agree that the parenting plan may change depending on the location of where the minor children are enrolled in school for the 2026-2027 school year. Now, someone explain to me what that means?
Well, Judge, since I was part of, with Ms. Franklin trying to create this plan with these folks, we sat down, and because we knew that Mr. Washington might move, and also in anticipation of them developing a more better co-parenting relationship, that in July we would revisit it so that we could come up with an alternative schedule was the plan.
Well, I know you were not involved in the initial filing of this proceeding, but the court is of the opinion that we don't really have anything filed before this court that would allow me to make a modification of the parenting plan. What it sounds like is that Mr. Washington may have envisioned that he was going to relocate, and you all agreed to this, but said that it will last until July the 12th of 2026, and thereafter, something else is going to have to happen.
Yes, sir.
But no petition has been filed to modify that parenting plan. There's only an opposition to the relocation.
This is a textbook example of procedure overruling substance. The judge is essentially saying, I understand the concern, but you filed the wrong type of case. That's a frustrating moment for many litigants, because they may feel they've presented valid arguments, only to learn that the court cannot address them through the legal vehicle they've chosen. Notice the distinction being made. The relocation statute wasn't triggered because the move did not meet the legal requirements necessary for a relocation challenge. Therefore, if the mother wants the parenting arrangement changed, she must pursue a modification of the parenting plan instead. In other words, the dispute isn't necessarily over, but this particular lawsuit may be.
Right.
That has not been triggered by the statute. Therefore, this court is of the opinion, I don't have anything before me today that would allow me one way or the other to rule in what you're requesting. I think you are free to, without prejudice, to file a petition to modify the parenting plan based on the very fact that it was envisioned that it would be modified. The question then becomes, is that going to do away with the requirement of a change of material, a change of circumstances, which is normally what is required to change a parenting plan? But based on my review, while this has been going on, of this parenting plan in this particular case, I'm of the opinion that I must dismiss this action because it does not meet the criteria for a opposition to a parental relocation, and give you leave to file a petition to modify the parenting plan as envisioned in subsection J1 of your parenting plan that would address these issues. Ms. Toka, I'm of the opinion that this is the appropriate way to handle it. So,
And if that were to happen, Your Honor, and they would have leave, obviously, like you say, to modify, to file a petition to modify, if that's what they want to do, would there be any objection to Mr. Washington enrolling the children in his new school district, since he is
he's
the
the primary
primary?
residential parent. Under the parenting plan they agreed upon, they have joint decision making, but if they cannot agree, he makes all the educational final decisions. So enrolling the children in a different school is an educational decision. So I would suggest that if you're going to oppose that, Ms. Coffenberry, you need to get something filed to modify the petition, the parenting plan, get a petition filed and try to get a hearing as soon as possible. Because obviously it's within his purview under that agreed order that he be allowed to make these decisions. So,
All right.
all right.
Well, that's what we'll do, Your Honor. Thank you.
And so,
Dismiss.
Your Honor, I'll submit an order that reflects that.
Just make sure that it shows that this court's of the opinion that because the parenting plan, parental relocation was not triggered by the distance requirement, and there was this case cited by you in one of your filings that I have read, and it is correct. It is not the lineal miles, it is the direct miles that govern it. So if you'll put in there that the court doesn't find that this has been triggered by the relocation of Mr. Washington, and that it would be necessary for a petition to be filed to modify the parenting plan in order.
What a fascinating ending to this hearing. The judge ultimately did not rule on whether changing schools was a good idea, nor did the court determine which parent had the stronger argument regarding the children's best interests. Instead, The case turned on a procedural issue. Because the relocation statute was not triggered by the father's move, the court concluded that the mother's opposition could not proceed in its current form. However, the judge also pointed directly to the parenting plan itself, indicating that a future petition to modify the agreement may be the proper path forward. For now, the father remains the primary residential parent under the existing order, and the court signaled that educational decisions likely fall within the authority granted by that agreement unless a modification is successfully sought. This case serves as a powerful reminder that in family law, the wording of court orders can be just as important as the facts themselves. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.